Sentences are determined in white-collar criminal cases through a very complex procedure, and they rely on what's called the United States Sentencing Guidelines, which is essentially a thick book of rules that govern how sentences are determined. Now, it's important to understand that the United States Sentencing Guidelines are not mandatory anymore. They used to be mandatory. So there used to be this very complex calculation that would result in a determination of a range of months that someone was eligible to be sentenced to. Then a federal judge would, at the time, this is before 2004, a federal judge would have no discretion to sentence outside of that range of months. There was a Supreme Court case that was issued in 2004 that said that that system is unconstitutional, that the guidelines cannot be mandatory. So now the guidelines are what's called advisory. And what the law says is that judges must consider the guidelines and they must establish that same range of months through the complex calculation. Judges don't have to sentence within that range. They can go below the range or they can go above the range. So the way sentences are determined is, again, through this complex procedure. So what happens is there's a finding of guilt, and whether a person pleads guilty to a charge, admits their guilt in open court, or they go to trial and they're found guilty. At that point, there will be a sentencing order issued, which issues deadlines by which certain documents have to be filed. And then a few weeks later, there's an interview where the person who's just been found guilty participates in an interview with a probation officer. And that interview goes into the person's biography, goes into schooling, family history, work history, any substance abuse issues, things of that nature. The probation officer then creates a draft of the report that will eventually, in final form, go to the judge, who will use that to help determine a sentence. Part of that report also contains a sentencing guidelines analysis. After that interview is done, both the prosecution and the defense, they take the draft of that report, they review it, they make proposed changes to it, and then a final version is submitted to the judge. The defense, in preparing for a sentencing hearing, will gather letters of support from family members, co-workers, mentors, teachers, etc., in order to give the judge the best picture of the person who's about to be sentenced. To give the judge a picture that comes from a broad range of sources, to show the judge that just because this person got convicted of a certain type of charge doesn't mean they need to be going to prison for an extended period of time, or it's used to justify a sentence of probation. So once these letters are gathered from the variety of sources, a sentencing memo is written by the defense team. Prosecutors typically write a memo as well, and those are both submitted to the judge in preparation for the sentencing hearing. Then at the sentencing hearing, both the prosecutor and defense counsel are able to speak to the judge, and first to talk about any potential or outstanding issues that remain with respect to the pre-sentence report. So for example, if in the pre-sentence report there is a factor that's added to potentially increase someone's sentence, then typically defense counsel will want to speak to the judge and say, listen, you shouldn't be considering this factor. The potential sentence, the advisory sentence in terms of months, should be lower. And then the prosecutor may come in and say, well, we have our own position on this, and it actually should be higher. And then the judge will make a decision about what the advisory sentencing guideline range is. Once that advisory sentencing guideline range is established, then both sides will then make a presentation as to what the final sentence should be. And then finally, the defendant has an opportunity to speak or not to speak. They don't have to speak to the judge. And typically with my clients, I have them write a letter to the judge, so the judge already knows what they would say, and then if there are additional comments that my client wants to make, they can make them, and then the judge issues a sentence.